Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera. Good morning, everybody. Can I get some cue whether or not you can hear my voice? Is the audio visible on your side? Loud and clear. Okay.
Good morning, all.
Sorry for the hiccup just now. Okay, let's proceed with the session. So welcome to MEF free webinar today. And the topic of discussion is on the latest amendment to the Employment Act. And for today, we have two speakers. We have two segments actually. The first segment will be discussing on MEF role, function, and services. And it will be delivered by Puan Haja Haslina, our Senior Manager for our Membership and Strategic Communication Division. The talk will be 1 hour. After Puan Haslina, we have another session, which is the highlights for today, which is the latest amendment to the Employment Act with our Principal Consultant for Industrial Relations, Mr. Nantha Kumar. Without further ado, I would like to call our first speaker, Puan Haja Haslina, to deliver her talk on MEF role, function, and services. Amendment to the Employment Act with our Principal Consultant for Industrial Relations, Mr. Nantha Kumar. Without further ado, I would like to call our first speaker, Puan Haja Haslina, to deliver her talk on MEF role, function, and services. Amendment to the Employment Act.
Okay. Assalamualaikum. Salam 26 Ramadan today. And a very good morning to all of you. Thank you for your patience due to some technicalities this morning. So please cheer up. Today is Monday, no Monday blues. We all should be alert, because Raya is coming very soon. Okay, now. So 26 Ramadan today. The thing is, thank you, Tuan Haji Anis Fahmi, for the brief introduction and inviting me to make the ball rolling. I will just take about perhaps half an hour only, for the overview of MEF roles, functions, and services. For those of you online who are already our members, please take this opportunity just to refresh of our MEF functions, the roles and the services that we are providing to all our members out there. And for those of you who is coming for the first time on MEF online free webinars such as this one, this is just to brief you and how MEF can be of assistance to you, particularly if you are an employer or you are an HR practitioner out there, because MEF is an organization for employers in the country. Okay, now let us move on. As an organization which has been established, I think for the last 64 years, we have set our vision very clearly that MEF is to be the premier employer's representative, and we are a recognized employers organization at the national level, which is the peringkat negara, regional, the peringkat serantau, and international levels, as well as we strive to be the leader in the development of human resources, as well as to promote the good employment practices and harmonious industrial relations with a view to achieving national objectives, which is quite mouthful. Anyway, never mind. The slides which are coming later will explain and elaborate to you what do we mean by all these vision statements. Okay, so what is MEF? It is actually the point of reference for the views of employers in Malaysia in particular. Okay, we also have the trust of the employers in the country that MEF expresses the business needs of employers. And we also represent the Malaysian employers in the country. Yeah. Okay. Why do we stress the fact that it is to express the business needs of employers? Okay. Let me just explain to you. Because when we talk about employers, of course, back in your mind, you will be thinking that our dealing is only on employment matters. Okay, tidak. Because as MEF has been standing very tall for the last 64 years, kita punya involvement is not only with the with the Ministry of Human Resources for that matter, yeah, because business needs ni merangkumi even for like MITI, yeah, international trade matters, even like KDN, yeah, Kementerian Dalam Negeri on foreign workers, on intake of foreign workers in Malaysia and whatnot. Even for the contohnya the Ministry of Higher Learning on issues of TVET dan juga unemployment of graduates dan sebagainya. That's why we put that as expressing the business needs of employers per se. Okay, now, so all these pictures capture what I have been telling you, that MEF is actually the voice of employers, because at any time, even the ministry or the government, yeah, dan juga kalau mass media, if they want to get employers' views, MEF will be contacted, right? So, ini yang lain-lain contohnya, okay. So, you can see all the topics of interest, yeah, on adaptability to getting hired, you know, to address Malaysia's labour shortage, yeah, and then tindakan kepada majikan yang menipu, untuk membendung COVID-19 di tempat kerja, dan juga for MEF, we are nothing new ataupun strange lah, you know, stranger in the sense that macam programs like Money Matters, the live talk show, yeah, even macam bernama, and even like Karang Craft Forum, yeah. So normally we will be invited to express the views of employers. Okay, now, so we are the place for employers or HR personnel to seek professional assistance whenever they deal with employment issues. Okay. So in short, what is MEF? We are the central organization of private sector employers, yeah, as I repeat, in Malaysia, and we get recognition at the national, regional and international levels. And the milestone of MEF, as you can see, we were established way back in May 1959. So sehingga sekarang, so 64 years already, yeah. And currently where I am talking, we are based at the headquarters, which is located in Petaling Jaya, and we have 246 other locations where our branch offices are servicing our members nationwide. And when we make self-acclaim that we get the recognition at the national level, the two slides here will explain to you why we say so. Because, for example, all these councils or boards, yeah, dia punya representation comprising or consisting of the three parties, which is the employers, the government, and the employees. Contohnya, the NLAC, that is the highest council discussing labour issues in the country. So MEF has a representative there. Even for the National Wages Consultative Council, EPF Board, MPC Board, NIOSH Board dan sebagainya. Now, even for SOCSO kan, we also have representative at the SOCSO Appellate Board, yeah, and for the technical vocational education, we also have a representative there. Now, when we say that we are recognized at the regional levels, okay, this slide shows you in which for ACE, which is the ASEAN Confederation of Employers, as well as at the Asia Pacific level, which is the association which we call Confederation of Asia Pacific Employers. MEF is actually a founder member of all these associations of employers, be it at the ASEAN level as well as the Asia Pacific level. Yeah. Okay, and at the international level, MEF is a member of IOE, International Organization of Employers, which has some 140 plus employers organizations as members worldwide. Yeah, so MEF pernah juga I think the last almost 10 years ago, 5 to 10 years ago, our president was elected as the chairman of the IOE. Yeah? So that is the recognition being given to Malaysia then. Okay, sekarang pun ada jugalah. Okay, and then for every year, we are also invited to participate together with the Ministry of Human Resource. Normally, it's being represented by the Honourable Minister, dan juga representatives from the union comprising MTUC dan juga QPEX, dan di pihak majikan, which is of course MEF. The three parties will be invited to participate actively to highlight the views, the concerns of Malaysian employers. Should there be any new ratification, all those international labour issues at the International Labour Conference in Geneva. Okay, now, so how do we play our role in getting ourselves and we make claims that we are being recognized at the national level? In particular, if you can see, earlier on, I did mention to you that MEF express the business needs of employers. So we make ourselves actively, proactively participating in the various government dialogues. Misalnya tadi, as I mentioned to you, like not only with the MOHR, even with MITI, with Ministry of Finance, even with MOHE, MOE, even with the Kementerian Dalam Negeri, on all the entire spectrum of issues of the interest of employers, yeah. And we also make representation on various matters. Misalnya tadi, kalau let's say if we want to say contohnya, before prior to the announcement of budget lah, contohnya by the Menteri Keuangan. So all the inputs, they will be getting from the various industries, which MEF is also one of the representatives of the employers who will put up a very strong vocal voice on the interest. Apa-apa pun, the interest is on for the employers in Malaysia, yeah. Okay, itu adalah contoh-contohnya. Okay, now, when we say that we are being established dah lama, we are actually being recognized as the employers organisation. Kita sebenarnya ialah, we are an association, in fact. We are registered under the ROS, Register of Societies Act, yeah. And of course, what is an association without ahli, without members? Okay, now, so when we say that members, we serve members, okay, what you can see on the slide, the current slide is the 5 main ataupun the 5 major services that our members are enjoying. Okay, number one is of course the core activity of MEF is industrial relations. Okay, so this one nanti I explain how it is, and then the second one is big data. Big data, research and information. We conduct surveys, getting all the views, all the inputs from the various industries among our membership to put up to the government. Okay, this is the the outcome of our survey, yang akan menyumbang kepada keputusan by the various kerajaan ataupun ministries of the government, yeah. Okay, lepas tu IT, of course, and then we also have OSH, Tadi the moderator, he himself is our OSH consultant in MEF, and we also have our training arm, which is actually a subsidiary of MEF, because we have established Malaysia MEF Academy. Besides, in spite of just having training as an arm within MEF, kita ada training academy. Jadi I will explain to you all these 5 main services. Okay. But before I proceed, this is something which I would like to stress the fact that number 1, we are a registered association for employers. Okay. Jadi kalau we have members, of course our members will pay annual subscription to retain membership, as well as to get all the entire spectrum of services which of interest to you, as members. And kita punya services actually being divided into 2 category, which is number 1, it is free-based services. Okay, free-based services is, of course, when you are a registered member, these are the services you are getting free. Okay, kalau kata there are certain category of services where whenever we have to charge members, okay, it will be very minimally charged. And for the fee-based services, certain services, we also open to non-members. Okay, don't worry, I will just explain to you the free-based services first. Okay, of course, when I say that the core activity tadi, it is on advice and guidance. When you are our member, at any time you can make use of our consultants, their expertise, their knowledge, to advise you via phone, email, fax, members portal, and even face-to-face. It's better for you to fix an appointment to see our consultant prior to coming to our office. Okay, so that is consultation at our premises. It is, of course, is free. Okay, now, and then you will also be getting regular email blasts. Okay, our email blast ni, it is one of the things that our members like, because there will be emails on kita punya meeting, the meeting minutes, the courses, the training courses, that are upcoming, our seminars, conferences. And then let's say kalau katakan ada new announcements by the various ministries. Contohnya kalau macam during COVID hari tu, the MOH mengeluarkan new rulings, regulations dan sebagainya, we will advise through our email. Alright, now, lepas tu, the free-based services also include simple written opinion on HR issues. The keyword is simple. Kalau complex and complicated, that one which we would require the time of our consultants to redo ke, to really pen down, their thoughts very deeply involved. That one will be chargeable lah. Okay, tapi ini simple. Contohnya katakan you are non-member now, later on you say, why not we become MEF member, contohnya. Jadi simple written opinion, contohnya the letter of appointment. Katakanlah your company has been using that for the last 10 years. Dulu HR dulu yang dah retired, yang put down the letter of appointment. Jadi why not you take the letter to the attention of our IR consultant, minta dia punya pandangan, the view. That one is considered as simple written opinion lah. Okay, now, lepas tu monthly meetings. This is something that you should not miss, because being in membership, sometimes company membuat alasan, I don't really use your services. I tak ada masalah, but I never ask your consultant. Oh, tidak. The thing is that monthly meetings are ongoing. The name is monthly. Jadi you shouldn't miss the meetings, because, of course, monthly meetings, it is a platform, a very important platform for networking. Okay, you in the HR line, of course, you need network kan. Jadi it is a very good networking. Number 1, monthly meetings ni is scheduled ahead. Ya, misalnya kata if you are in the Central Region, it is the third Wednesday of the month. Jadi dah tahulah anggarannya hari Rabu minggu ketiga contohnya. Okey. That one is schedule lah. Tapi kalau macam kata minggu ketiga tu falls on hari raya, kita pun ubahlah tarikh tu. Tapi not to worry. Lepas tu contohnya for the Selangor, Putrajaya, Shah Alam semua, it is on the second Tuesday of the month. Okay, what do our monthly meetings offer you? Okay, number one, kita ada the agenda, the first hour of the agenda tu kebanyakan kaliannya ada the talk slot. Contohnya kita bukan kata allow any members nak buat sales talk ke tidak. Anything of the interest of the employers. Contohnya katakan among the membership ada satu new announcement from EPF contohnya. Jadi we will invite an EPF officer untuk address members dalam setengah jam je lah. Okey, lepas tu contohnya lagi setengah jam tu kita punya consultant misalnya katalah Tuan Haji Anis Fahmi tadi will give you an overview of the latest regulations in OSH Act contohnya macam tu. Tapi lepas tu the remaining hour of the meeting tu will be discussion on current disputes. Okay, meeting kita tak lama, normally dalam 2 jam lah, 2 jam lebih macam tu, and currently it is conducted online. Jadi attendance wise full, I tell you, berbanding dengan face to face, kalau online ni kita boleh dapat sekali meeting dalam 200 lebih. And then that is a very good thing. Lagi satu, tak ada restriction. Misalnya kata one company, you punya the whole HR team nak masuk 5 orang, silakan. Jadi that is the monthly meeting. Kalau kata you miss a meeting this time, kita akan ada minutes of meeting provided to you lah. Okay, lepas tu kalau kata, sukalah, terlepas meeting tu, okay, next meeting yang contohnya you are in the central, you nak masuk in Selangor Putrajaya, we will allow you to, because it is free. Okay, now, lepas tu you are a member, you will have access to MEF members portal. Jadi sekarang ni kita bagi each member company 4 persons within your organisation to have MEF members portal access. By we will be providing you the user ID password log on lah. Jadi contohnya tak ada alasan lah. Misalnya kata, alamak, the HR manager kita on maternity sekarang 98 hari kan. 3 bulan lebih kita tak dapat apa-apa. Tidak. 3 orang lagi boleh memainkan peranan to have access to our members portal. Okay. Lepas tu, with the MCO sebelum ni, kita pun created our WhatsApp group. Okay, WhatsApp group ni interaktif. Tapi janganlah membebankan diri in which sampai 24 jam nak hantar message kan. Tidak. Kita WhatsApp group ni macam ni. Kita allow one company, just one person will be allowed to be in the WhatsApp group. Jadi all the information yang relevant sahaja we will allow because admin kita akan control lah. Okay, now lepas tu yang fee pula. Fee ni kena dengar. Okay, kalau kata your company has court cases. Court sini please bear in mind we only represent for labour court dengan industrial court cases sahaja. I think last week ada satu company panicky dah kata, alamak dia ada high court case. High court case kita tak boleh tolong. Alright, only court representation. Lepas tu yang kedua is consultancy packages. Consultancy packages ni misalnya kata your company would like us to do HR or OSH audit. Kita ada consultancy package for that. Okay. Lagi satu consultancy package ni katakan your company would like to come out with a new revised company handbook. Ada juga. That falls under consultancy packages. Okay. Kalau handbook punya matter, sama ada we start from scratch or kita dah ada the handbook tapi you would like us to review. Jadi because it falls under consultancy package, kita ada dia punya range of prices lah. Jadi kalau kata kita propose to you, this is the fee, negotiate ke whatsoever depending on the complexity of the document lah. Okay, and then it can also be translated lah dua bahasa, English and BM and vice versa lah. Okay, that falls under consultancy packages. Then dua ni, court representation dengan consultancy packages, it is a fee-based service and it is only open exclusively for MEF members. Okay, akan tetapi the remaining 3 bullets down there, seminars, webinars, conferences, training courses, publications, kita open members and non-members. Okay, kalau non-members, of course, harga dia lebih tinggi from members. Members will be getting discount. For certain conferences, seminars, all that, kita ada lagi cantik dia punya package tu, in which kalau kata you actively participate tahun lepas ke, the year before, kita ada berapa 5%, 10% discount dan sebagainya. So, jadi nampak clear to you, free and fee-based services. I just need a little bit of time to explain this because saya tak nak nanti later on, hey, we are your member, how come you are charging us on this? Jadi ada yang free, ada yang fee-based, ya. Okay, now, jadi this one untuk just to sum up on IR tadi, your advisory, opinion by phone, fax dan sebagainya, WhatsApp group is there, and then court representation only in these 2 courts, and then conciliation at IR department, di bawah Akta IR Act. Only MEF is allowed to go in lah. You tak boleh bawa you punya companion, good lawyer ke whatever, tak boleh. Okay, only MEF is allowed untuk menemani, untuk to represent the employer in IR department conciliation cases, and then monthly meetings, training on IR and HR audit. Okay, now, okay, kita move on to big data. Big data ni, nama dia pun big data. Jadi memang kita kumpul data banyak lah. Okay, research and information services, which falls into these main categories: surveys and publications, library resource center, dan juga economic and labour data. Okay, now. Okay, buku ni sebenarnya untuk salary survey for non-executives and executives ada 2 thick volume. Currently, I tell you, walaupun kita ni kan orang moden ni kadang canggih, kita nak semua e-book lah, tapi permintaan terhadap physical books yang tebal macam ni masih relevant, ya, because banyak company still nak. Jadi sekarang ni we are working on lah for the e-book dan sebagainya, tapi itu akan datang. Currently, we are still selling our publications dalam format of physical books like this. You see the thickness of the books. Okay, sekarangnya, kalau katakan salary survey for executives dengan non-executives ni, saya rasa untuk tahun ni dah tahun yang ke-28, ke-29 lah, macam ni untuk tahun 2022. In which, we will send out the survey forms, the survey questions to all our members throughout the country. Ya, kita ada 6,000 lebih sekarang ni ordinary members dan 28 industry groups. So siapa yang willingly lah to take part in our survey, we will reward them later on melalui good discount when they purchase these books. Okay, and our survey publications, the results of the survey normally will be announced dalam bulan 11, penghujung bulan 11 macam itu. Dan survey ni selalunya kita dalam bulan 9 tak silap saya, kita launch the survey, kita compile and we tabulate and we come up with the reports and we will call the press lah to announce the findings. Biasanya our findings of our survey books memang dinanti-nantikan because we will call the press a press conference where we will highlight. Contohnya what is the prediction lah from our analysis, the increment for executives benchmark position. For non-executives, increment itu increment. What is the projection of bonus payment by companies in Malaysia, something like that lah. Dan yang cantiknya, what I would like to stress the fact that our salary survey reports are being captured and used by contohnya MOF, by MIDA, ya, untuk WU investment to the country dan sebagainya lah. Ini antara yang menggunakan every year. Dan juga kita punya ahli-ahli lah, yang bukan ahli pun kadang-kadang join kita sebab dia nakkan buku-buku ni. See how useful the data is. Okay, right. Yang ni pula another survey series where kita pun juga buat fringe benefit survey. Fringe benefit ni kita tak buat every year lah, unlike the salary survey tadi. Fringe benefits ni probably 2 tahun, 3 tahun sekali. And then yang buku lagi satu, as you can see down there, is the analysis of CAs and awards on terms and conditions of employment. Yang ni kita dapat kerjasama daripada Perjabatan Perhubungan Perusahaan. Itu macam satu bank of CAs lah dekat the respective ministry. Lepas tu kita MEF mendapat kerjasama, kita take all the the CAs, kita analyse, kita tabulate and we come up with this report. And it is also a very useful tool for companies particularly yang having unions to refer to this book. Lepas tu yang macam yang survey on implementation of WFH, implementation of work flexible arrangement whatsoever tu kita akan buat lah from time to time. Okay, yang ni pula IR series. As you can see lah buku-buku yang kita keluarkan. Okay, one point, our books are not available at bookshops. You pergilah Kinokuniya ke Popular ke, memang tak ada, only in MEF. Okay, now jadi of course members ada harga lain, non-members ada harga lain. Okay, contohnya Probationers and the Law ni, buku pink tu kita keluarkan baru late last year when we had our IR conference. Kita masukkan sekali, all the participants will be getting a copy of the book. Kalau nak beli separately, individually, independently, kita ada jual jugalah members and non-members. Buku hijau tu, practical guide. Okay, bear in mind that in MEF we have a pool of experts in IR. Kita ada all those very experienced and knowledgeable people. Even kita ada ex-judge of industrial court who are with us now upon their retirement. Dan juga yang lain-lain dengan dia punya years of wealth of experience. Jadi we make them to write, to pen down their experience. Jadi itulah kita katakan practical guide. Because ini bukan a normal textbook. Macam okay, you nak ikut ke whatsoever, tidak. It's a practical guide. Kita akan ada buat column where we would advise and guide you accordingly lah, based on the HR management practices, the best practices of HR. Okay, ini antara contoh-contoh buku-buku, dan buku-buku kita masih dijual. Sentiasa dijual sepanjang tahun. Okay, now move on to MEF Academy. Inilah saya katakan tadi, we are not only having a training arm within MEF, kita we established an academy. Sebabnya bukan sahaja short courses ataupun weekend courses yang kita buat untuk, of course, orang-orang dewasa macam kita yang bekerja sambil nak belajar, e-learning, upskilling of knowledge dan sebagainya. Kita juga offer diploma, degree and master's courses with our collaboration with some prestigious universities dan juga dengan collaboration with industry specialists. Okay, jadi this is our MEF Academy di bawah satu bumbung at MEF HQ. And we are recognized by HRDC and our courses are claimable from HRDC. And kita pun mendapat international recognition on HR and labour issues from the ILO. Okay, right. Jadi some of the highlights of the academy ni, as you can see, our courses mencakupi daripada HRM, HRD, it is continuous improvement and development of HR and soft skills programs, On IR, of course, the experts, the pool of experts are here. Kita tak ambil orang lain dah, memang orang kita saja within MEF. Kita juga menggunakan kepakaran kita punya OSH consultant to develop new programs and to collaborate with industry specialists on NIOSH. Kita juga collaborate with industry specialists untuk courses yang kita tak ada kepakaran. Yang tu mengaku pula kita tak ada kepakaran in terms of apa? In terms of finance and taxation, in terms of IT misalnya, courses society dan sebagainya. Okay, for taxation actually untuk MEF sendiri ya, kita every year kita menganjurkan hasil MEF tax seminar. Okay, jadi untuk tahun ni kita dah launch hari tu the kickstart. It was in Setia City and lepas raya ni kita akan continue. Jadi for those of you, please watch out, visit kita punya website dan juga kita punya portal untuk tahu venue dan seterusnya. It is a very overwhelming punya kind of response lah that we received from members dan juga non-members on our tax seminar. Okay, lepas tu exact academic program tu macam saya cakapkan tadi, kita buat executive diploma program, certification courses. Executive diploma program kita ada modul daripada ILO. Jadi kita punya our levers of our diploma programs, I tell you, selalunya lah kena pinch lah dengan good companies all that because of dia punya accreditation yang kita dapat lah from our diploma programs ya. Lepas tu conferences and seminars ya. Okay, now ini other events lah. We even take part in exhibition dan sebagainya. Okay. On membership sekejap. Okay, there are two classes of membership. If you are out there, you are a sendiri berhad, you are enterprise, ataupun you micro lah, you kecil, you just ada contohnya 2 orang employees ke sebagainya. As long as you are a registered business entity, you can join us as ordinary member. Okay, yang association member tu andai kata your company as an industry di bawah satu association. Contohnya kata you are under the association of contohnya plastic manufacturers contohnya, itu association tu boleh join kita as association membership dengan syarat dia punya ahli-ahli dia ialah company lah in that particular industry. Itu je syarat dia. Okay, so for ordinary membership kita categorize into 2, single company and group. Single company is a very straightforward thing lah. You operate under one sendirian berhad ke, one enterprise, that's it. Kalau kata you ada branch dekat Penang ke, dekat Muar ke, tapi menggunakan nama yang sama, it is only branch, it is single company. Okay, kalau group pula, it is for a holding company where you have 2 or more subsidiaries dengan syarat the HR and IR functions are centralized to the mother company, to the holding company. You may opt to join as a group member. Ini kalau macam kata you are holding company, FYZ holding, okay? You ada anak syarikat, FYZ marketing sendirian berhad, okay? FYZ import export sendirian berhad contohnya. Okay, jadi dengan syarat FYZ marketing ni tadi, FYZ import export ni dia punya HR function is centralized to FYZ holding tadi, boleh opt to get them to join as a group member. Macam tu Okay, now entrance fee, it is one off payment, 500 sahaja sekali seumur hidup. 500. And then annual subscription depending on the total workforce of your organisation. Jadi kita kira per head lah. Kalau company you ada 10 orang, kira the first 100 employees kali RM10. Jadi 100. Macam tu. Tapi adakah you kena bayar 100? Contohnya. Kalau kata company you ada 350 orang, you ikut the formula. The first 100 employees RM10 per employee dah 1,000. Second 100 RM8 per employee dah 800. The third 100 employees RM6 seorang kali jadi 600. Jadi campur 1,800 campur 600 jadi RM2,400. The 50 orang tadi tu is RM1 per employee. Jadi 2,450. That is your annual subscription. Okay? Tadi menjawab soalan tadi, adakah 10 orang you nak bayar 100? Tidak, sebab kita subject to a minimum of RM1,000. Ya, maximum RM6,000. Apalah sangat RM1,000 for 1 year. 1 calendar year bahagi dengan 12 bulan. Jadi kalau you kena bayar RM1,000, it is only around RM83 sahaja sebulan, in which there is the orang kata investment lah. You bayar RM83 sebulan untuk dapatkan all the professional services yang kita cakapkan tadi. Maksimum ni RM6,000. Kalau company you besar, ada dalam 3,900 orang dan ke atas, boleh you bayar RM6,000. Kalau tidak, it will be between RM1,000 ke RM6,000. Okay, now Jadi association ni a quick one. Kita ada 6 kategori. Okay, ini saya tunjukkanlah contoh-contoh yang our industry groups yang jadi kita punya association members. Ada insurance, ada commercial banks, ya, ada chamber of commerce, ada apa tu dan sebagainya lah, timber, plastik, textile, stevedores, engineering, machinery, financial planning dan sebagainya. Okay. Now, jadi currently kita ada 6,000 lebih lah, and still slowly but steadily we are increasing. Ya, jadi kita punya ahli as of end March, kita dah meliputi almost 3 million lah employees, because sekarang ni employees dia dah mengurang because banyak companies yang buat downsizing dan juga mengecilkan the workforce of their companies. Okay, now. Jadi di mana kita our offices are located, as you can see, kita dekat Northern Region, kita ada di Seberang Jaya, office kita yang sekarang ni currently servicing dalam 430 companies lah. Perak is the Perak state alone, kita ada satu office di Ipoh. Central Region, of course the biggest, because kita cover Selangor, Putrajaya, KL, Negeri Sembilan, dan Melaka, ada 5,000 lebih companies di situ. Southern Region kita jaga Johor sahaja. East Coast, of course, we are located at Kuantan, tapi kita jaga all the 3 states up there. Dan East Malaysia kita ada 2 office, satu di KK, satu lagi di Kuching, right now. Jadi sekarang ni, okay, ini orang kata raya promo. Alamak, dah nak habis sebenarnya. So for those of you who are out there yang masih belum jadi member, raya promo kita ialah kita waive the entrance fee of RM500 tu. Okay lah, save lah companies money RM500. Okay, tapi ingat sampai 30 April ni, berapa hari je lagi adalah seminggu lebih je lagi. So beritahu dengan you punya boss, the decision maker, why not we give it a try, jadi ahli MEF for 1 year dulu. Kita polish apa-apa yang tak perlu, apa-apa yang patut kan. Okay, give it a try lah, like Puan Haslina said. Okay, alright. Lepas tu ini new member incentive scheme. This is something which kalau kata you out there, you introduce, you jadi orang kata apa, introducer lah to your friend, to become MEF member, we will reward you cash RM450. Cantik kan, RM450. Okay, tapi akan tetapi okay, dia ada TNC lah. Biasalah kita nak bagi orang tapi kita ada TNC kan. Okay, now. Tadi tu kalau new waiver tu, kalau company yang you introduce, dia ambil waiver tu RM500, okay, so you are not eligible for this one. Tapi kita sebenarnya tengah create satu insentif, kita akan bagi you voucher for you to redeem for publications, dan juga probably untuk kita akan bagi juga voucher for you to redeem untuk conferences kita. Okay. Jadi orang kata win-win situation lah. Right now. Jadi that is our team. Kita sebelum saya mengundur diri, saya would like to encourage you, strongly encourage you, visitlah kita punya social media, jadilah kita punya follower, be active, and kalau ada apa-apa inquiries on MEF membership, tolong, that is our membership punya inbox, email address, So selamat hari raya. Kalau saya ada tersilap cakap ke apa, maaf zahir dan batin. I would like to see you to become MEF member and enjoy the benefits of membership. Thank you so much. Okay.
Okay, thank you Puan Hajah Haslina for the introduction to MEF. Puan Haslina, can you hear me now?
Very loud and clear.
Okay, so my laptop is now fixed. Okay, without further ado, let's go to the second session. So the second session roughly will start at 10:25 to 11. Hopefully, hopefully to 11 or extended a bit. So the topic for the next session is the latest amendment to the Employment Act. And to deliver this topic, we have our own principal consultant, Mr. V. Nantha Kumar. He has been with MEF since 2009. 2009, he has been representing MEF members member companies at industrial court, conciliation proceeding, collective agreement negotiation, and labor court cases. He has extensive experience in IR matter, including consulting, advisory, and conducting training on various industrial relation topics, which include disciplinary procedure, the Employment Act and Regulation, the Industrial Relation Act, termination of employment, and collective bargaining. He has prior working experience with a commercial bank. After qualifying as an advocate and solicitor in 2005, he practiced with Ms. Sriram and Co. and Ms. P. Kupusami and Co., specializing in employment law before joining MEF. So without further ado, let us welcome our principal consultant, Mr. Nantha, to deliver the highlights of the amendment to the Employment Act. Over to you, sir.
Good morning, members and all. Thank you, Encik Anis, for that introduction. Ladies and gentlemen, as Encik Anis said, my name is Mr. Nantha Kumar. I'm one of the principal consultant for industrial relations with MEF. So for this morning, I will share with you all the key points and highlights of the latest amendments to the Employment Act that took effect from 1st January 2023. I will share the slides. Just bear with me. I'm one of the principal consultant for industrial relations with MEF. Okay, is the slides can be seen by everybody? The key points and highlights of the latest amendment. Can I have a feedback? Is the slides okay? The mode from 1st January 2020.
Yes, Mr. Nantha, I can see the slides.
Okay, thank you, Janice. So, as the time is rather limited, I will focus on the relevant amendments to the Employment Act for this morning's presentation. And following my presentation, which should take about hopefully we can I can end it by 11, and then we will have the opportunity to have a question and answer session by our members as well as those who are aspiring members. Okay, so let me get into the presentation itself. So the Employment Act basically, of course, is an act relating to employment standards. Employment Act, the whole purpose of the Employment Act is to provide minimum standards of employment for categories of employees as specified in the first schedule. So the latest amendments that were passed last year, in May last year, and it was originally supposed to come into effect on 1st September 22, but then employers requested for more time. MEF lobbied the government, and government gave additional time for employers to prepare, and the amendments will took effect from 1st January 2023. Okay, now what are the sections of the Employment Act that have been amendments? So as you can see, the parts highlighted in red are parts that there were some amendments, all right? And part 9, for example, maternity protection, I'm sure many of you are aware there have been some changes. Now the new section is part 9 is called pregnancy and maternity. Later I will go through what are the amendments, all right, and some of the others as well. Okay, for the very first time in the Employment Act, we have a section that alludes to flexible working arrangements, right? So these are some of the changes that are in the amendments to the Employment Act. Okay, now the Section 2 of the Employment Act talks about, refers to what are the key definitions of some important terms, definition of words that are relevant to the Employment Act. For example, uh, if we talk about, it goes by alphabetical order. What are the important terms that is referred to in the Employment Act? For example, if we look at A, there is a term called Approved Incentive Payment Scheme. Now, what is this Approved Incentive Payment Scheme? It is a scheme if employer wants to introduce some kind of incentive scheme uh, where the employer can register that scheme with the labor department, and if it is approved, that's why the word approved is there, then whatever payment that the employer makes under this scheme, it will be excluded from the calculation of wages. Okay, so this is the one of the draws for this particular scheme. All right, so this is one example. Another example can be, okay, if employer wants to know for um, uh, maternity, what is the definition of the word confinement, right? So the Employment Act defines confinement as childbirth of a child or children after at least 22 weeks of pregnancy. I mean, this is just the summary, right? The full definition is in section 2 under the term confinement, right? It doesn't matter whether the child is born alive or in unfortunate situations dead, right? Any childbirth after 22 weeks of pregnancy is defined as confinement, right? So these are some of the terms that is referred to in the Employment Act. Apprentice. Apprentice is defined in the Employment Act, right? What it means is any person who has entered into a contract, an apprenticeship contract. So apprenticeship contract means a written contract entered into by a person with an employer who undertakes to employ the person and train or have him trained systematically for a trade for a specified period, right? Previously, it just says shall not be less than 2 years. So with the amendments now, apprentice training contract shall be minimum period of 6 months and a maximum period of 24 months, in the course of which the apprenticeship is bound to work in the employer's service. So as far as the Employment Act is concerned, the definition of an apprentice is that they are an employee of the company under an apprenticeship contract. I know many employees may ask, what about the other one, interns? Well, interns are actually not defined in the Employment Act. So that means if they're not defined in the Employment Act, that means interns are not employees of the company. Interns are just there for probably, in between their studies, they come, they just want to get some on the job kind of experience for a few months. And therefore, they, whatever agreement they have with the company, they are just paid an allowance and things like that. Okay, so the key terms on the Employment Act you want to know, please refer to section 2 of the Employment Act, right? A day is defined in the Employment Act as 24 hours beginning at midnight. Okay, this is some of the examples. All right, now moving on. Okay, here we have a important definition of who is an employee under the Employment Act. So I think this is a very important definition. Now, as you can see, the words highlighted in red are the amendments to the first schedule of the Employment Act. It now defines employee as any person who has entered into a contract of service. Okay, so with the latest amendments to the Employment Act, previously before 31st December, sorry, excuse me, before 1st January 2023, okay, say for example last year, the Employment Act coverage mandatory applies to only two groups of employees. One is those whose wages, monthly wages were 2,000 and below. Okay. And the other group is those whose nature of a job is a manual work. These were the two groups who were previously mandatory covered under the Employment Act. All the other category of employees, they were outside the scope of the Employment Act. However, with the latest amendments, there has been a drastic change. Effective 1st January, the Employment Act applies across the board to any person who has a contract of service, irrespective of the job position or how much you earn, right? So from the lowest ranking employee right up to even the general manager and even the managing director, if they have a contract of a service, can be covered under the scope of the Employment Act now. Okay, that is the first thing I think all of you must take note. If you are not aware, if you're already aware, I'm sure most of you are aware, but if you are not aware, then this is the first thing you must. Everybody is now under the scope of the Employment Act as long as you have a contract of service. Now, the only after intense lobbying and compromise, so what the government has allowed for employers, okay, is the first schedule also says any person whose wages exceeds 4,000 a month, 4,000 a month, 4,000 and above, then these sections, certain sections of the Employment Act will not apply. Just a few sections, but these are a critical section in terms of the cost to the employers. Section 60 sub 3, 60A3, 60C2A, 60D sub 3, and 60D sub 4 deals with employees working on rest day, employees working on off day, sorry, not off day, public holiday, as well as those who are doing overtime work. Okay. These amendments, anybody whose wages are above 4,000 monthly, they are excluded from these sections. Okay, that means they are not mandatorily covered when it comes to overtime payment, payment for working on a rest day, payment for working on a public holiday. All right, they are excluded. Right, but anybody whose wages is 4,000 and below, okay, irrespective whatever job, they are now entitled for overtime payment, payment for working on a rest day, payment for working on a public holiday. And employees whose nature of a job is manual labor, no matter how much they earn, right, monthly, 3,000, 4,000, 5,000, they are covered under the Employment Act for overtime and things like that. So I think this is the key definition that the members as well as women must be aware. Okay, 4,000 and below, everybody is mandatory covered by the Employment Act. Above 4,000, these sections only don't apply. Working on a public holiday, working on a rest day, overtime, do not apply. But the remaining sections of the Employment Act, for example, um, medical leave, hospitalization leave, annual leave, working hours, all these things now apply to everybody across the board. Okay, this is the thing that you must be aware and take note. All right. Okay. Now, the another important definition under the Employment Act for employers as well, especially HR practitioners, IR practitioners, what is the definition of wages? Section 2 of the Employment Act defines wages as being made out of two components. One is basic wages. Okay, basic wages plus any payment for work done under the contract of employment. Okay, so these are the two components, basic wages plus any other payment for work done. Now, the definition of wages then goes on to say what are the exceptions that can be excluded. Okay, so section 2, someone gives several examples of what are the payments that can be excluded. All right. Now, if the employer gives, for example, housing, accommodation, food provided by the employer and all those things, that is excluded. Okay. Uh, Traveling allowance specifically is mentioned as one of the items that can be excluded from the definition of wages. So if an employer gives an employee a traveling allowance, a month, say monthly 300 ringgit or whatever, that payment can be excluded from the calculation of wages. All right. Payment to defray special expense, any reimbursement of cost to the employees is of course not part of wages. Gratuity payment, not part of wages. Bonus, any kind of annual bonus is also not part of the wages. Now, coming back to the top part, we say here, value of any house, accommodation, food is not included. What this means is, for example, if your employer provides you with the housing accommodation, your employer pays for your housing accommodation. Let's say the house rental is 1,000. The employer pays that 1,000 directly to the landlord. That means the employer bears the cost. So that 1,000 is definitely not part of wages. However, in the other hand, if the employer pays the employee a housing allowance, where the employer says, I give you housing allowance 1,000 ringgit every month is paid in with the employee's wages. That means it appears in the salary slip. Okay, 1,000 ringgit cash housing allowance given to the employee. In that kind of a situation, that housing allowance payment is part of wages. This is what you must understand. Okay, if it's paid in cash and it appears in the employee's pay slip, then whatever allowance, it is part of wages. The only allowance that is exempted specifically under section 2 is the traveling allowance. All other types of allowance, handphone allowance, childcare allowance, if it paid in cash and appears in the employee's pay slip, it is part of wages. Okay, this is what you must understand. If the employer directly bears the cost, that means it doesn't appear in the pay slip, this is taken care of the employer, then of course it is not part of the employee's wages. Okay, so this is how you look at it. Any doubt, any clarification, always refer back to section 2 of the Employment Act for the definition of wages. If something is not listed as an exception, it's not there, you search for it, that means most likely that payment is part of wages. One of the most common example is commission. Commission earned by the employee is not listed as an exception. That means it is part of the employee's wages. Okay, so that is important to take note, right? Because why you need to know the correct definition of wages? Because this is involves later on you want to calculate a payment of overtime to the employee, payment for work done on the public holiday, the rates. So the first starting point, you must get the proper definition and calculation of the employee's wages. Okay, right. Moving on, contract of service. So the contract of service, remember, the starting point, first schedule says anybody now who has a contract of service is an employee of the company. So what is the definition of contract of service under the Employment Act? Any agreement, whether oral or in writing, and whether expressed and implied, whereby one person agreed to employ another as an employee, and that other agrees to serve his employer as an employee. And this includes, as we saw earlier, apprenticeship contract. So if you have a contract of service, you are an employee of the company, right? Okay. The other opposite of contract of service is contract for service. Contract of service is a document signed between two persons where a contract is between a principal and a contractor to carry out whole or any part of work undertaken by the principal in the course or for the purposes of the principal trade or business. The biggest difference between contract for service and contract of service is that contract of service, there is an employer-employee relationship. One person is the employer, the other person is the employee. Whereas if you say contract for service, there is no employer-employee relationship. It's only an agreement between a principal, the company, and a contractor for service. Okay, later I will talk more in detail what makes a contract for service. There is a new amendment to the Employment Act, Section 101C, which talks more in detail about the meaning of contract for service. All right. Okay. Now, Employment Act sets out the minimum terms and conditions of employment. All right. Now, if there now since the Employment Act applies across the board to all employees, if there is any clause in the employment contract which is less favorable than the minimum standard set by the Employment Act, then that clause is void and no effect. For example, let's talk about medical and hospitalization leave. Employment Act says the hospitalization leave for 1 year for an employee is 60 days. So if your contract of employment, for example, where your employer says your hospitalization leave entitlement in 1 year is 30 days, beginning from January 1st, that clause is void and no effect. Why? Because now everybody is covered under Employment Act. You must comply with the minimum terms of any standard set by the Employment Act. So hospitalization minimum 60 days. Employer cannot give less than that. Okay, that is what it means under Section 7. The minimum terms of the Employment Act will apply. However, if your contract of employment has more favorable terms than the Employment Act, then the more favorable terms will apply. Okay, so that is how Section 7 deals with the terms and conditions of Employment Act. Okay. Like I said, I will only concentrate on the amendments to the Employment Act. I'm not going to go through the entire Employment Act because that is simply not possible. Today's aim is to highlight what are the amendments that came into force on 1st January 2023. Okay? Right. So these are some of the things that I will, not really go through. But anyway, very quickly, notice of termination. The Employment Act sets minimum notice of termination for the employees. Uh, if there is an existing notice of termination clause in the contract, that can apply. In the absence of a written notice in the contract of employment, then the Employment Act notice of termination will apply. Okay. All right. Okay. Now we have Section 14 of the Employment Act. For the very first time, this now applies to everybody. All right. So basically, very quickly, Section 14 talks of a situation where if an employee is terminated for special reasons. Here, special reasons means for disciplinary misconduct. So what are the requirements under the Section 14? There's a requirement of a due inquiry before the employer. If there is an allegation of misconduct, there must be a due inquiry before the punishment is taken. What is this due inquiry? It's a bit different. It doesn't mean domestic inquiry. What it means is basically before the employer takes any kind of action, the employer gives an opportunity to the accused employee to respond. So if you issue a show cause letter, all right, and you give the employer a chance to reply to the allegation, that is part of the due inquiry process. All right. Now, the punishments that is available to the employer include, of course, immediate dismissal if they are found guilty of a misconduct, downgrade. For the first time, it applies to everybody now. The downgrading is one of the options for punishment, and any other lesser punishment, including 2 weeks suspension without pay as a punishment, right? So the important thing is whatever action the employer takes as a punishment, prior to that, you must do the due inquiry process. Please, the biggest mistake many employers make is, unfortunately, sometimes they jump the gun. They straight go for the punishment without the due inquiry process. If you do that, then it's a breach of Section 14. Okay, so please take note of that. All right. Right. So Section 14 also allows suspension of an employee pending investigation. The maximum provided by the Employment Act is 2 weeks on half pay. Okay. If you need to expand the suspension more than that, then it must be on full pay. You cannot suspend an employee without pay pending investigation. That is a breach of the law. Punishment, if found guilty, one of the punishments available to the employer is you can punish the employee by up to 2 weeks without pay. That is after they've been found guilty of any misconduct. All right. Moving on. Okay. So I'm not going to cover every single thing except, okay, very quickly, we will touch on Section 15.2 because this is one of the clauses that actually employers have to deal a lot with. Section 15.2 of the Employment Act deals with a situation where if an employee is absent for more than 2 days, it can amount to a breach of contract. Okay. Now, the most important thing for the employers that I have to share is that don't make the mistake of immediately when an employee is absent for more than 2 days, 3 days, employers straight away issue the letter breach of contract because employee absent for 3 days. You do that, then you are asking for trouble because that's a breach of the law. What you must do is, like what is stated in Section 14, you must have a due inquiry process. Here, the due inquiry is very simple. If an employee is absent, what you should do, after 2 or 3 days, you issue a show cause letter to the employee, giving the employee the chance to explain his absence and report back to work. If the employee fails to respond or fails to reply and does not report back to work after the deadline given, then you can issue a letter of breach of contract. Okay, so this is the thing you have to be. Many employers rather make the mistake of assuming Section 15(2) is an automatic clause where if the employee is absent more than 2 days, employer can straight away issue the letter of breach of contract. No, it is a two-step process. First step, you must issue the show cause letter. Only if the employee does not reply, no reason, or even if they reply, they don't have a valid reason, then you can go to the second stage, which is the breach of contract. Okay? Okay, part 3 deals with payment of wages. Okay, payment of wages must be done by way of a bank account. All right. Now, the new section 18A, all right, this is a new amendment to simplify the calculation for employees' wages if they join service, like halfway during the month, and how do you calculate? So with this new amendment, it is very straightforward. You just follow the calendar month, right? So now we are in the month of April, right? So if an employee joins service halfway during the month, 15 days, so you divide 15 over 30 times whatever his pay salary is. Then you get the amount. So you follow the calendar month based in the new. Last time the Employment Act was silent, so there was some confusion whether you use 26 days, working days and stuff. No. Now simple, you just follow the calendar month. All right. So in monthly wages, number of days of the particular wage period. So here refers to the calendar month of that wage period, and then number of days eligible. How many days the employee worked for that month. Okay, so that is the calculation. Now the wages, okay, you must pay by the end of the month, or you got a grace period of 7 days. All right. Now the amendments that I want to show you is to deal with the deduction of wages. Okay, very quickly, when it comes to deduction of wages, employers, please be careful. Deduction of wages, please refer to Section 24. All right. Whatever deduction must be authorized by the Employment Act. All right. So Section 24 says there are 3 circumstances where the employer can make a deduction from the employee's wages without their consent. Meaning to say, if you overpaid an employee's wages in the preceding 3 months, okay, say for example in the month of December, maybe you overpaid the employee's bonus or something like that, and if the mistake is discovered within 3 months, January, February, March, you can recover the overpayment of the wages, right? The other situation is if the employee has absconded without giving notice. If there is any salary due that the employer hasn't paid, you can offset the salary with the short notice. The other one is if the employer gives an advance, salary advance, you can make deductions by the subsequent months' wages. This is the lawful deductions under Section 24. So there are some other deductions where you need the consent of the employee. Okay, if you're going to make a payment to a third party and things like that, the employee asks, you need to get the agreement. There are some other payment, not only the employee's agreement, but you must also get the approval of the Labor Department DG, right? This is, for example, if employer, for example, you give salary advance, but the employer charges interest. That kind of situation, you need to get approval from the Labor Department. right? And also, some other payments you need to get their authorization. So please refer to what do you call this, section 24 when it comes to the deduction of wages. Okay. Now, payment of wages. Okay, payment of wages. There are some amendments to the Employment Act. They've replaced the word through the bank. They now say financial institution. Okay, the important part is this. Okay, right. So now you have section 25, payment of wages other than through a financial institution. Sometimes the employees, they may come and ask the employer, can you make my payment by cash or by check? The standard format for payment of wages now under the Employment Act is through a financial institution. You credit directly the employee's account. Sometimes they may ask to make payment in check or cash. It is allowed. Previously, if the employee asks you in writing, if the employer agrees, it's not a problem. Now with the amendments, it says here, the employer shall, upon the written request of his employee under subsection 1, obtain approval from the Director General for the payment of wages to be paid in legal tender or check. So now no more just employer giving permission. You want to pay cash or check to the employee, you must get the approval of the Labor Department. So this is a significant change in the payment of the employee's wages. Simply an employee make a request writing, you simply cannot approve on your own. You must also get the permission of the Labor Department. So this is a significant change. Employers must be aware. Okay. Subcontractors principles, not really, no changes as such. Okay, it's just that now contractor for labor, there's an additional requirement. They must be registered with the Labor Department. And if they don't register and things like that, then action can be taken against the subcontractors. So if you are using outsourced labor companies, please ensure they are properly registered with the Labor Department. Otherwise, if you go into agreement with unregistered outsourced labor provider, then the company itself also can get into trouble. Okay. Okay. This is another a section. There's some changes, I'm sure. Now it's previously used to call maternity protection. Now it's called pregnancy and maternity. What it says here is the changes. Of course, I'm sure everybody is aware now. The biggest change is the eligible period for the maternity leave allowance is 60 to 98 days. All right. Now, the rest of it is still the same. Okay. So I won't go into the details, except there is a new section that deals here, section 41A. Okay, this is a new amendment. It's part of the pregnancy and maternity protection. So what it says here, section 41A, restriction of termination of pregnant female employee. So here we are talking a situation before maternity, while an female employee is pregnant. So now there is an added new clause giving protection to a female employee who is pregnant, where it says here, where a female employee is pregnant or is suffering from illness arising out of pregnancy, it shall be an offense for her employer to terminate her services or give notice of termination, except on 3 grounds. Okay? If the employee has willful breach of a condition of the contract of service, of course, can do that. If the employee has committed a misconduct, okay, or if there is a closure of the employer's business. So these are the only three situations where the employer can terminate the services of a female employee who is pregnant, right? If where the service of the female employee under subsection 1 is terminated, the burden of proving that such termination is not on the ground of her pregnancy or ground of an illness arising of pregnancy shall rest on the employer. So this is an important section you must take note. Okay, if you were terminated a female pregnant employee who's pregnant, the burden of proving that that termination had nothing to do with the employee's pregnancy or any illness related to the pregnancy is on the employer. Previously, the law is silent. Okay, now section 41 is there. And this is an additional protection for female employees who are pregnant. So the summary is, yes, if there is some justification, if the employee has done something to breach the contract or she has done a misconduct, you can definitely take action. However, you must be careful to ensure that it is nothing to done in a way that is victimizing the employee because she is pregnant. Because the burden of proof is on the employer. Okay, so this is something important to take note. Okay, the rest of it is the same. So I will not go into the detail. Okay, hours of work. Okay, there is additional changes. Employers can say the biggest change is, of course, as we can see here, highlighted in red. All right, the hours of work. Okay, sorry. Employers can say the biggest change is, of course, yes. As we can see here. Okay, here, section 60A about the working hours. So the biggest change, of course, now is employers have to comply is the change from the maximum normal working hours from 48 to 45 hours in a week. Okay, now this one, let me highlight a point to you. What do we mean by what do we mean by working hours? Normal work hours, okay, this is section 60A3, okay. The definition of normal working hours as in the Employment Act, it says is the number of hours of work agreed between employer and employee in the contract of service to be the usual hours of work per day, subject to the limits imposed in section 60A. So what this means is, for example, in your company, if you all are practicing a 5-day week and the normal working hours is 8 hours a day, so 8 times 5 is 40 hours. So when we talk of normal working hours, for the employees whose contract is a 5-day week, 8 hours a day, their normal working hours is 40 hours. The 45 hours referred to the Employment Act is the maximum allowed in 1 week as a normal working hours. But if your contract says the normal work hours in 1 week is 40 hours, then for you, that is the normal hours of work. And overtime is defined as any work, okay, number of hours work carried out in excess of the normal hours of work per day. So that's simple. So in your contract, if the normal working hours in 1 day is 8 hours, if you do any work beyond that, then it's overtime. Right? So you want to know your normal working hours? Refer to the contract of employment. What is the normal working hours for that particular employee or that company? right? And then overtime is defined as any work done outside the normal work hours per day as per the contract of employment. So this is the two critical things here. All right. You want to know your normal hour? Refer. It's not in the Employment Act. Employment Act just says what is the maximum hours allowed as normal working hours. Now, previously used to be 48 hours a week. Now it's pushed down to 45 hours a week. Okay, so this is the thing to take note of. All right. Um, Maximum an employee can work in one day is 12 hours. All right. That is made up of, for normal employees, 8 hours normal work hours plus 4 hours overtime. An employer cannot require an employee to work more than 12 days, 12 hours, unless there's some emergency situation. Okay. Right. The other changes, okay. Public holidays and all that, there are no changes. All right. But remember, for the very first time, all these sections now apply to all employees. All right. These are the sections. I will only focus on the amendments because we do not have enough time to go. Okay. This one, amendments to the hospitalization and sick leave. Previously, the Employment Act, prior to the amendments, stated that in one calendar year, the maximum limit of the hospitalization plus normal sick leave is capped at 60 days. Now, with the latest amendments, the normal MC and hospitalization are separated. They are no longer combined. So an employee, depending on their years of service, you have 14, 18 or 22 days normal MC. Then hospitalization is treated separately, 60 days. So in theory, now an employee can have 60 days hospitalization plus an additional, if they work more than 5 years, 22 days of normal MC. Last time, the combined limit is capped at 60 days in 1 year. Now it's segregated. Okay, so that's the important thing to take note of. The rest of the sick leave, no. Okay. What is the new amendment? Section 60 FA, for the very first time, fathers, you have the paternity leave provision. Okay. So section 60 FA says a married male employee shall be entitled for paid paternity leave at ordinary pay for a period of 7 consecutive days. 7 consecutive days means, let's say the baby is born on Monday straight to Sunday. It doesn't say working days, 7 consecutive days. And the other requirement is the paternity leave shall be restricted to 5 confinements. 5 confinements means, starting from 1st January 2023, the requirement is that the employee, the criteria to qualify for the paternity leave, the employee must be in service minimum 1 year. So after the 1 year, he is eligible to have this paternity leave, all right, for up to 5 confinements. That means 5 children. Now, what if he has prior children before this paternity leave amendment to come into action? Doesn't matter, because this is a new benefit provided by the Employment Act. So the employee, irrespective of previous children he has, no, it's still eligible for 5 occasions of the confinement. Unlike for the female employee, confinement, the word used is 5 surviving children. Here, for paternity leave, they don't use the definition. It just says 5 confinements. So, after January 1st, 2023, an eligible male employee eligible for 5 occasions of confinement to enjoy the paternity leave. Okay, so what are the other amendments that affects the employers? Okay. Okay, foreign employment of foreign employees. For the first time, there is a requirement now for the employer who engages foreign employees. It says here, Amendment 60K. No employer shall employ a foreign employee unless prior approval has been obtained from the Director General. So this definition of foreign employee includes expatriates. Okay, so for the first time now, you need approval from the Director General of the Labour Department. Last time it's just the Human Resource Ministry and the Immigration Department. So now you need approval from the Director General of the Labour Department as well, for any foreign employee. Okay, so you have any doubt, anything, please contact the JTK. You must get the DG's approval. Okay. What are the other important changes? As you can see, a lot of the amendments when it comes to the penalties, the penalties have last time used to be quite often 10,000 ringgit is the max. Now the penalties have all been increased. 10,000 has become 50,000 for most of the offences. So you have to be very careful, to ensure that you don't breach any of the provisions of the Employment Act. Okay. Flexible working arrangement for the very first time is in section 60P. So flexible working arrangement is actually a very general amendment. All it says for the first time, the employee, all right, an employee, it says subject to Part 12 or anything contained in the contract of service. An employee may apply to an employer for a flexible working arrangement to vary the hours of work. There are three types of variations the employee can apply for. Vary the hours of work, days of work, or place of work in relation to his employment. So the employee, for the first time, the law says there's a provision you can apply. Okay. Subsection 2 says where there is a collective agreement, any application made by the employee under this section shall be consistent with the terms and conditions of the collective agreement. Now, upon application, the employer, upon the application made under subsection 1, an employer shall within 60 days must official of the date of the application received must decide to either approve or refuse the application. So the decision to allow or not allow is up to the employer. But if the employer chooses not to approve the application, the employer must give the reason. Why is it not allowed? Okay, that's all the section says. So ultimately, it is a decision of the employer to decide whether to allow or not allow. Okay, employee can make the application, and if there's already an existing, some companies may already have an existing work from home policy or anything like that, then that policy can apply, because the section here says subject to Part 12 or anything contained in the contract of service. So if the contract of service or the employee handbook already has a pre-existing company policy on work from home, that policy can apply. The employee, if the employee puts in an application, the employer can say, we already have such a policy, so please ensure that your application is in line with the company policy. If there's no such policy, then the employer can decide on a case-by-case basis. Okay, and if this rejected, you must give the reason. The only advice I can give is just make sure that this application for work from home, or vary the hours of work, or vary the days of work. Maybe the employee wants to work 4 times a week instead of 5 days. The company should be consistent in applying this to all the eligible employees. Okay. All right. What are the other amendments? Okay. You see, for example, if the penalty is previously is 10,000, now is 50,000 typically, right? So this is you have to be careful. Breach. Now, under Section 69B of the Employment Act, the Director General has the power, okay, to inquire into any dispute between an employee and employer in respect of wages or any other payments in cash due to the employee. If there's a dispute between the employer and employee, maybe the employee says, "Oh, you underpaid me my commission, or whatever payment is not correct," the employee can complain to the Labour Department. The Labour Department then have a right to look into the dispute. Previously, the limit was kept at employees whose wages are up to 5,000 ringgit. Now that limit has been deleted. Section 69B with the limitation has been deleted. So that means it is now open to any employee irrespective of their wages. So you may be earning 6,000, 7,000, and then there's the dispute, some payment of the wages the employee says is not correct. That employee is eligible to file a complaint in the Labour Department. Okay, so that's another thing you should take note of. Previously, only those earning up to 5,000. Now that 5,000 limit has been deleted. Okay. For the very first time, this is another section, 69F, new section put into the Employment Act. Risk is called discrimination in employment, right? So here, it's a very general clause, and it's also very wide-ranging. It says here, the Director General may inquire into and decide any dispute between an employee and his employer in respect of any matter relating to discrimination in employment. And the Director General may, pursuant to such a decision, make an order. So if an employee perceives in any way, that my employer is not being fair to me, or unfair, or, discriminating, they can make a complaint to Labour. Any employment-related matter. So I used to say, even the situation now, if an employee, doesn't get bonus, or they get lesser bonus than other employees, if they feel they are being victimized or whatever, in theory, they can complain to the Labour Department. And then there's no limit. There's no limit. Any employee. So this discrimination in employment is a new clause. Employers must be aware, must be very careful now on how you treat your employees. Okay, so all these sections, amendments are new. We don't know the implications yet because it's so new that no cases yet. As far as we are aware at the Labour Court, all this may happen over the next 1-2 years, when employer and employees are both getting used to these new changes. But this section is there, so please take note. 69F, title for the first time, discrimination in employment. Last time, it is all silent on this issue. Sexual harassment, same thing. There's no real changes. This one is already been there. The final one, I think see the penalties again have been increased. Like I mentioned just now. Last time 10,000, now it's all 50,000. So be careful. Breaches can be very expensive. The part okay, section 81H. There's a slight addition to the sexual harassment part. It says notice on sexual harassment. Now there's a requirement: an employer shall at all times exhibit conspicuously at the place of employment a notice to raise awareness of sexual harassment. So at least in your reception area, or where the employees or anybody who comes into the company's premises can conspicuously see, you should display some notice in any form saying that the company is, for example, anti-sexual harassment, that kind of thing. Because if you don't have such a notice displayed at the prominent place at your workplace, if the labor department officers come checking, they say, hey, why no notice display? Then they can cite you for being breach of section 81H. So please take note of that. A simple notice to raise awareness on sexual harassment is sufficient. Okay. This one is if there's a court dispute, court order about payments due to the employee, there's some changes. You can look it up. It's not so important. Okay. First time there's a section on forced labor. Section 90B, there's a new section, forced labor. Any employer who threatens, deceives, or forces an employee to do any activity, service, or work and prevents that employee from proceeding beyond the place or area where such activity, service, or work is done commits an offense and shall be conviction be liable to fine not exceeding 100,000 ringgit. I think this is more for to protect the foreign workers and any employees who are abused or deceived in their employment terms and conditions in any way. Okay, but anyway, this clause is there, so you must take note. And the last part is this is the one that I talked to you very much earlier. This is a new section 101C. The title of that part section is Presumption as to who is an employee and employer. Basically, like I mentioned just now, if the company engages somebody under a contract for service, so you are telling, I'm engaging you to provide a service, and in return for that service, I pay you a fee, you are not my employee. Okay, it's a contract for service. But let's say there is a dispute arising, and that other person then says, actually, I'm your employee, even though the contract says contract for service. Now, for the first time, Section 101C of the Employment Act states, for the purpose of this section, it shall be presumed until the contrary is proved that a person is an employer. Okay, so if there's a dispute, one party says you are not my employee, the other party says no, I am your employee, the burden of proof is on the company to show that the other person is not an employee, because the law says now it shall be presumed until contrary is proved that a person is an employer, where he or she controls or directs the manner of work of another person and controls the hours of work and things like that, right? So similarly, sorry, for example, if you engage a person to do work and you put contract for service, but actually what happens is that person reports to the company, that person complies with the company's instruction, the working hours they comply, with the working hours of the company. The equipment or the tools needed to do the job is provided by the company. So if these are the kind of situation, then even though the contract may say contract for service, if there's a dispute, and now with section 101C, which clearly says if there is a dispute, the burden of proof is on the company to show that the person is not an employee, then it makes it very difficult for the company to say that other person is not an employee. So you have to be very careful. Simply putting on paper and calling it contract for service is not good enough. The section 106 goes how the conduct of the parties. How did you treat the other person? Did you get them to follow your instruction? Did you get them to follow your working hours? Did you provide them with the tools, the equipment to do the job? If you have done all these things, then they are your employee, no matter what the paper says. Okay, so please take note of section 101C. It says the presumption of it shall be presumed until contrary is proof that a person is an employer. So the company is an employer until you show evidence that the other person is not an employee. They are a genuine contractor for service. Okay, so please refer to section 101C. So I've reached the end of my presentation for the amendments to the Employment Act. I think I'm open now to to take any questions that you may have with regards to the amendments. I hand you back, Encik Anis.
Okay, thank you, Mr. Nantha, for the brief introduction to the amendment to the law. So now we open for question and answer session, and you can either ask about MEF, it will be answered by Puan Haja Haslina, but if it is on amendment to the Employment Act, then Mr. Nantha will respond to your question. So you can unmute your microphone and directly identify yourself and ask the question. Okay, let's have the first question. Anybody? Kalau ada soalan boleh tanya sama ada berkaitan MEF akan dijawab oleh Puan Haja Aslina. Kalau berkaitan dengan akta pekerjaan akan dijawab oleh Mr. Nantha lah. Bebaslah nak tanya bahasa Melayu boleh. If you prefer in English, then you can ask in English. Or if you are quite shy, you can write down your question in the chat box or meeting chat. Then I will read the question to our panel. Okay, silakan. Any question? If not, then we can conclude the session. It's easier for us. Kalau tak ada. By the way, please bear in mind also that we do have amendment to the Occupational Safety and Health Act. And the penalty is also being severe now, tenfold more than what we have currently, which is maximum 50,000 ringgit. So have a look at the amendment to the OSHA Act. By the way, if you have question on OSHA Act amendment also, you can post a question here, and I would be happy to answer for you. By the way, I'm Anis, and I'm here as the OSH consultant, and so I'm quite familiar with what's happening in the OSHA Act. Okay. So no question. Semua malu nak tanya ke dah lapar? Puasa, tak ada soalan. Okay, kalau tak, okay, we have a question from Saidatul, Saidatul Nafisah Shahrin, referring to this is for Mr. Nantha, referring to section 60K, kalau expatriate dah ada, still have to ask permission from DG? Okay, we have a question. Mr. Nantha.
Okay. No, it only applies effective 1st January for any new hires. If you have already existing this one, no need. Okay, starting 1st January, any new hires after that only.
Okay, so clear. The new one lah, the existing one no need lah.
Yeah.
Okay, from Linda Yong. Linda Yong, sir, I would like to know if the employer has contributed EPF for the contract for service contractor. Can later the person claim that he is the employee of the company?
Okay, that's a good question. So, like what I referred to with the now with Section 101C, the presumption on who is an employer and employee, the burden of proof now is on the company. Kalau if the company is saying, I give you a contract for service, you are an independent contractor, you are not my employee. But then at the same time, company has gone and paid EPF contribution for that person. So then the question will arise, if they are not your employee, why do you make the EPF contribution? So this burden of proof now will fall on the company, right? So of course, if you have done something by conduct to treat that person as an employee, then as per Section 101, so the law will say that is assumed you are the employer. So you have to be very careful lah. So when you say contract for service, like I was explaining, the genuine meaning is no employer employment relationship. So accordingly, you must treat the contract as such. So once you do things like contribute EPF, or provide the person with the tools and the equipment, use company premises to do the work, then all these things give the presumption that you are the employer. Okay. Yeah.
Okay. Okay, this one is on OSHA, so let me uh, go through the question. Will the changes in OSHA be notified to MEF member? We have been informing our members on the amendment since last year, and we have done a few briefing in our regional group on the new changes to the law. So it is an ongoing process, and by the way, this year, starting from May onwards, we will be having a few workshop on OSHA Act amendment, which is a joint program with Perkeso. So it will be a physical session, and hopefully members of MEF would attend those sessions so we can get clearer information by the representative from DOSH on the matter. But it will be May onwards. But as far as we have done for the last year, we have been informing our members through our meetings, and also through a briefing on the new amendment. But anyhow, for members, if you have any query, feel free to email me, and I will normally respond to the email on the specifics question, because it is the buzzword out there now, the OSHA Act amendment lah. Okay, anything on membership that you want to ask, please. Haja Hasina is still around, I hope. She will be happy to answer your question. Okay, we have another one for Mr. Nantha. The EA Amendment Act has been enforced since January 2023. However, there are still some companies that are still in the process of implementing the requirement or change. Can you briefly explain the potential risk to the said company?
Okay, to answer that question, actually, employers, actually way back in May last year, when the amendments were passed, and they were originally scheduled to go into effect on 1st September 2022. So at that time already, the employers should have been aware. In fact, MEF has already, communicated this issue to all our members extensively. And after the lobbying by MEF on behalf of the employers, the government compromised and actually pushed forward the implementation date to 1st January 2023, meaning to say companies were given more than 4 months to prepare for the implementation. Okay, and then now we have come to 1st January, where now the act has taken effect. So if you are still in the process of implementing, it's understandable because the changes are actually quite wide-ranging. But I do understand at this moment in time, the Labour Department is not being very aggressive in the enforcement because it's still early days. So it is best to quickly ensure you take the opportunity to quickly implement the changes, so that maybe in 6 months time or next year they won't be so lenient. Where if there are breaches, then as you can see, as I highlighted, now the breaches, the penalty is much higher. So that's where you have to be careful. So what I would say is, if you are still doing, then you got to speed up the process and comply. My our understanding is, in fact, MEF has also lobbied the Labour Department to go slow on the enforcement, because it's still a learning process for the employers, and but you cannot expect it to go on too long lah. So that's my advice. I think there's one question about employee traveling overseas on medical leave.
Go ahead. Sorry, I was about to read that for you.
Yes. I mean, of course, if an employee is on medical leave, they are supposed to be resting and recuperating at home. So if there is evidence that the employee has traveled outstation overseas, the employer can always issue a show cause letter to the employee, asking the employee to explain under what circumstances they had traveled overseas or whatever when they're on medical leave. If they are found to be abusing their medical leave entitlement, then of course the company can take the appropriate disciplinary action. Okay, that's how I would say.
Okay, thank you, Mr. Nanta. From Lee Bao, what should employer do? Like set up OSH committee, member, or other plan in order to be compliant with the law? Okay, basically, it's quite difficult for me to explain here, but roughly, whatever you do, number one, make sure that the company has and establish the occupational safety and health policy. So that policy must be communicated to everybody. Number two, if your numbers are 40 and above, you must set up the safety and health committee establishment. So you need to make sure that you meet once in every 3 months on the committee. And number three, you must have risk assessment conducted. And so risk assessment is part of the law now. And number four, you must have SOP for specific emergency. And these are the new amendment. And the fifth one, you need to have a person by the title of occupational safety and health coordinator. This person will be the focal point between the company and DOSH. This is will come into force tentatively now. It's going to be June. So you need to send somebody to the OSH coordinator training, and MEF jointly with MSHOSH, we are conducting those programs on a monthly basis. So please have a look at our MEFA Academy schedule and register your staff to the OSH coordinator training so that you can prepare yourself for the new changes. Okay, so that would be my brief response to the changes to the OSHA Act.
Okay, there's one question on the Employment Act about Section 60P, which this is to deal with the flexible work arrangement. So the question is it practical to apply this section to the manufacturing industry, and will it be made compulsory by the government? Well, as it stands, that's why this section, all it says is gives the right to the employee to request. But as we all know, not every job can be done from home, or can be have flexible operations and things like that. So end of the day, the employer has the final say. Okay, definitely. If the company's business operations do not allow this flexibility, then too bad. The employer has to inform the employee, sorry, due to the nature of your job, it's just not possible to work from home or have the flexible hours, and you can justify it, it's no problem. That's why the government has allowed it, the employer to have the final say, for sure. Your question of will it be made compulsory by the government is unlikely, because there are some jobs, just by their nature cannot be done from home or cannot be done on a flexible basis. Okay.
Okay. We have a hand raised by Encik Faz Adnan. Go ahead, Encik Faz.
Yes.
If you have a question, orally you can ask us.
Yes. I want to ask regarding the especially those who are in manufacturing, how do we best prepare ourselves, especially for upcoming Hari Raya, because up until now we are not sure yet whether the Raya will fall on 21st or 22nd. And the announcement is only will be made on 20th 8 o'clock, the official announcement. So our worry is that our production is running 7/7. So employee is already in for 1 hour and then the announcement is made. And for example, if the Hari Raya like really brought forward to one day, like last year, how do we best prepare the company and how do we handle the payment for the employee who insists on going back for Hari Raya celebration? Can you advise on this?
Okay,
Right.
Mr. Nanta, it's yours lah, not mine.
It's a tough question. You're putting me in like running a business, but what I can advise employers is in anticipation of either Hari Raya falling on Friday or as scheduled is falling on Saturday, you can issue a memo to all the employees ahead, where the company can state out clearly what is the expectation if Raya falls on Friday. Okay, so what happens to the company's operations? And then option two is what happens if Raya falls as scheduled. I mean, at the moment, it falls on Saturday. So this memo can be pre-issued to the employees. So at least this communicates to them. They are aware. They are aware. These two situations, if Raya falls on Friday, this is what my employer expects us to do. Those who are pre-scheduled to work, maybe no choice. You have to work because your operations are running. So that is the preemptive thing you can definitely do. Because like you correctly said, if we wait until Thursday evening, then it's kind of very late in the day to suddenly jump and make the alternative arrangements. So that's the best advice I can give you. Issue a memo ahead where clearly it sets out the two scenarios and what is the company's expectation.
Okay,
Yep.
sorry, Mr. Nanta. Yes, we are doing that. On top of that, I want to check with you because what we announced is that if the Hari Raya falls on Friday, an employee requested to leave early, we say that we will allow, but then of course we'll need you to work for extra 2 hours. Means instead of going back on the dot 8 o'clock, we release you at 10 o'clock because there's some closure that needs to be done that we requires your support to do. Is it okay to do that?
I mean, of course, the employer has to look into both the operation of the business and where possible into the employees, how should I say, welfare. But of course, if the business needs, really can't be avoided, of course, you can put in these other requirements. But of course, taking into account the employees' welfare where possible, so you kind of have to find a compromise, definitely. But important thing is, like you said, please put everything in black and white ahead as soon as possible so that there is no confusion or misunderstanding on that day, at the last minute. That is the most important thing. Yeah.
Thank you.
Okay, Mr. Nanta, I think we have another one. Is monetary reward for employee referral program through personal recommendation, in bracket for hiring subjected to statutory deduction?
Uh, money. Okay, I think that's a technical, the tax question, Anis. I think the best advice I can give you is maybe you have to check with the LHDN or the EPF whether monetary reward for employee referral program. Well, if it goes into the payment goes into the employees' wages, this amount, then my understanding EPF, I mean, most of the payments is subject to the statutory deduction. You can check the EPF website. They have a very comprehensive list on what are the items that are subject to EPF deduction and contribution, right? If it's not there, it's a gray area. My advice is please contact them directly. Okay, because ultimately they are the decision maker in this kind of payment, whether it's subject to statutory deduction.
Okay, thank you. So I think that that conclude our session for today. I believe there's no
I
more.
think there's one
One
final
more.
question. I
Which
think
one is
that
it?
up there.
Mhm.
This person asks, how do company need to issue the new employment contract to take effect the EA amendment or no need? Do company need to issue a new? Oh no, you mean the changes to the Employment Act? Do you need to issue a new contract for the employees? No need. What you can do is you can issue a memo to all the existing employees, informing them of the relevant changes that affects their, for example, the working hours. If there's a change affecting the company, just issue a memo to the employees, informing them effect from 1st January. These are the changes to the working hours, etc. There's no need to issue a fresh employment contract.
Okay. Okay, thank you, Mr. Nantha. And for those who attended, who is in attendance today, thank you for your time. And please join MEF, because if you join as MEF member, apart from enjoying all our services, it will make us stronger in terms of voice. Whatever we want to give feedback to the government, it becomes stronger because we are a large pool of employers. So with that note, once again, thank
Sorry,
you.
Anis, last question I just saw there.
Oh,
Okay,
ada
quick
lagi.
one. The last one, all right. So
Okay, go ahead, go ahead.
for the 4,000 threshold, whether it includes fixed allowance, the answer is yes. So the wages component is basic wages plus any other fixed allowances payable. The only thing you can exclude is transport allowance. So if an employee's basic salary, let's say, is 3,800, and the company is paying the employee a fixed allowance of 500, so the total amount is 4,300. That is his wages. So he will be fall outside the scope of 4,000. Okay, that's how you look at it. Okay,
Okay,
Anis.
okay, it's
Final
okay,
one.
it's
Yep.
okay. Hopefully that's the final one.
Yeah.
Okay, no more, no more. Okay, so that's all for today. Thank you for your time. Selamat Hari Raya dan selamat berbuka. Thank you, everybody.
Yes. Selamat Hari Raya to all the Muslim participants today. Thank you.
Thank you.
Hopefully that's the final one. Okay, no more, no more. Okay, so that's all.